Welcome to the second webinar in our series on Retail Reboot, how to help small and medium-sized enterprises get back into business, survive and thrive in the new retail environment. My name is Andrew Murphy. I'm a senior lecturer in retail marketing at Massey University's Business School and in the Centre for Advanced Retail Studies. It's my great pleasure today to have two speakers from the legal community to speak about leases and legal considerations with e-commerce in particular. Marcus Bosch from Proactive Property Group and Katrina Hammond from Wynne Williams. Marcus.
Thank you very much, Andrew. Just a point of clarification. I am no longer a practicing solicitor. I used to practice law and then saw the light. So any technical or difficult questions, I'll just bump on to Katrina. Welcome everybody to this morning's webinar. I've been asked to talk about rebooting lease cash flows. And I appreciate that while we've been in lockdown, your focus has probably been primarily on your staff welfare and then secondly on your business cash flow. And as we come out of lockdown, you're probably going to turn your attention to what does that cash flow look like over the next 6 to 12 months. And you're probably aware that your lease costs are generally your second or third largest cash flow item behind your wages bill. Sales data that's coming through, Retail New Zealand indicates that retail sales in April 20 are 80% down on April 19. And the real question a lot of people are asking is what does retail sales look like post-lockdown as businesses grapple with social distancing constraints and we deal with the impact that COVID-19 has had on consumer confidence. And the real question comes down to what's our new normal in the retail operating environment. And the structure of my presentation today is I'm going to talk for the next 15 to 20 minutes, and then we're going to have a Q&A session for about 10 minutes following. I'm happy to email the slide deck out to you if you just send me your email address. I'm also happy to take questions as we're going, and I'll leave it for you to, if you can load them into the Q&A session. Unfortunately, I can't see them as they come up on my screen, so I will rely on Andrew to prompt me for a question, or alternatively, we can pick up your questions at the end of my presentation in the 10-minute Q&A. Given that we're going to need to initiate a conversation with our landlord around lease costs, my approach in today's talk is to outline a three-step approach that you can adopt to engaging with your landlord over your lease costs. So what I'd like to do is just give you a quick overview of that three-step process. Firstly, we're going to undertake a review. We're going to look at your numbers, both in terms of your lease costs and your actual and forecast sales. We're going to look at your lease rights and obligations that you currently have. We're also going to consider your landlord's position. Most likely that they're probably in the same boat as you. Second step is to develop options that we can table with our landlord. And there's two phases to that. There's options we can table during lockdown, which are probably limited to rent abatement or rent deferral. And then there's options to consider post-lockdown over the next 6 to 12 months as business and the economy comes out of lockdown. And the other thing we also need to develop or consider is what value can we deliver to the landlord, because we can't simply ask for a rent abatement or a rent reduction and offer nothing in return. And the third step to our process for engaging with our landlord is looking at how we're going to engage with the landlord. And I'd like to cover off mindset. I'd also like to talk about the relationship, and I'd also like to talk about the process that we'll go through in engaging with our landlord. So if we turn to review, first thing is to consider your numbers. I mean, you'll have actual sales results for a year to date, and you'll need to think about what your sales forecasts look like coming out of lockdown over the next 6 to 12 months. And you might want to run a few scenarios. You might want to look at how the GFC impacted sales last time round. Unfortunately, we're all using a new playbook and we're all entering new territory on this. But when we approach a landlord, we may need to be able to justify and quantify what we think our sales are going to be in order for the landlord to get confident that we've got a genuine case for dealing with our lease issues and in negotiating a rent reduction. The other thing to look at is your lease and your OPEX costs. You may also want to dig into your OPEX costs a wee bit more and see what items in there are discretionary in terms of marketing and admin functions, as opposed to your rates and OPEX, which are generally non-negotiable. The next thing is to look at your lease. Now, I appreciate that there's a range of lease formats out there. There's bespoke leases, there's mall-specific leases, and there's also a range of ALDS lease formats out there, depending on what year you negotiated your lease. And when you review your lease, if you're lucky enough to have an ADLS, a lease that's post-2012, there's a clause in there which is getting a lot of publicity at the moment, which is emergency access and your ability to negotiate a fair portion of rent in response to not being able to access your premises. The history behind this clause was that it was introduced post the Christchurch earthquakes, when tenants couldn't access their premises during the earthquake red zone period. A key difference between the lockdown for COVID-19 and not being able to access your premises during the earthquakes was that during the Christchurch earthquakes, landlords were able to access their insurance cover for loss of rents and were a lot more accommodating in their ability to grant rent rebates or defer rental for tenants who weren't able to access premises. With COVID-19, there has been no damage to property, so there's no ability for landlords to actually access insurance cover. So we're dealing with landlords who are actually having to fund the rent abatements themselves. However, unfortunately, the emergency access clause probably only relates to a very small percentage of leases in the marketplace. Another clause to consider, or another clause to look for in your lease is a force majeure clause. This basically is a clause that essentially frees up a party from contractual obligations if there's been an extraordinary or unforeseen event. It's more designed as a permanent, if there was a permanent event, permanently frustrating a contract, as opposed to a temporary as opposed to a temporary event like the lockdown because of the virus. But it's worth a conversation with your solicitor, and it's worth tabling it with your landlord to at least get them to the table. Other clauses to look for are your assignment clauses to see whether you've got the opportunity to assign and you can assign part or all of your premises. The other clause to look for is the ability to sublet either all or part of your premises. Another thing to look for in your lease is what is your expiry provisions, because there's always opportunities to either exit at expiry or to bring forward and have a negotiated exit. This is dependent on generally paying out a termination payment, or alternatively the landlord having in the wings another tenant that will take over your space. And lastly, you need to look at your personal guarantee obligations, whether there's an obligation to guarantee your lease. And if it is, it means you simply can't walk away from your lease obligations. Lastly, there's two other things to think about that aren't in your lease. There's the doctrine of frustration, which is a contract law doctrine that enables you to set aside contracts when there's unforeseen events that renders your contractual obligations undeliverable. Again, it's a permanent mechanism as opposed to a temporary mechanism, but it's worth a conversation and it's worth flagging as an issue to get your landlord to the negotiating table. There are also legislative proposals afoot. However, they probably don't go far enough to help you at this stage. All government is proposing to do is introduce a bill which extends the notice period that landlords need to give to tenants when they're going to terminate a lease for non-payment of rent from 10 working days to 30 working days. So that doesn't really help us in this situation. The next thing to look at is your landlord's position. And the first thing I would consider is the ownership period that your landlord's owned your building for, because that would be a good factor to indicate the level of debt that your landlord is carrying on the property, which will influence their level of flexibility. Also consider what type of landlord you've got, whether it's a private individual, whether it's a corporate, or whether it's a listed entity. Each of these different types of landlord will have different drivers which will influence their behaviours at the negotiating table. The other factor to consider is the negotiational conversation might actually be a three-way conversation between you, the tenant, and how much rent you can afford to pay your landlord, and with your landlord and how much mortgage payments that they can pay to the bank. And it might be the three parties need to align on expectations of cash flow. Lastly, you need to consider what value you can bring to the table. And I've taken the liberty of mocking up a little formula. R stands for rent, which is what you're paying, and cap rate is a percentage that we divide the rent by to calculate a value for the landlord's property. And depending on the value of the landlord's property, they can generally borrow 60% of that against their debt obligations. So that formula is quite important, because if we start playing around with the rent lever, that has a flow-on impact on value and on the landlord's mortgage covenant and obligations. And if we drop the rent by a significant amount, that impacts on value, and the landlord might actually breach their financial obligations. So it's important to bear in mind that when we're trying to negotiate with a landlord, what factors can we bring to the table which might influence the cap rate percentage? And I'll talk more about that when we look at our options. So having reviewed our situation, the next step is to develop some options that we can table with the landlord. And I take a very practical approach here, because regardless of what content is in or is not in our lease, at the end of the day, our lease does not contemplate COVID-19. It doesn't contemplate our economy being locked down, and it doesn't contemplate the potential of a recession we're now facing. So taking a practical perspective, during lockdown, we've got some limited options, and they essentially boil down to rent abatement, which is negotiating with the landlord to reduce the rent on a temporary basis while we don't have access to our premises. And we've achieved rent abatements between 40 to 100% for some of our clients. Where we haven't been able to achieve a rent abatement, we've looked at rent deferral, where we've negotiated a reduction or a deferral in the rent payment while we don't have access to the premises, on the basis that we make those rental payments up over the balance of the lease term. And with the end of lockdown in sight, we're now turning our attention to cash flow post-lockdown. And I've broken this down into two categories in terms of options on sort of a more temporary basis and options on a permanent basis. On a temporary basis, there's the option of negotiating a restructure of our rental flows with our landlord. Over the next 6 to 12 months, we look at reducing the rent that were payable now in exchange for paying a higher rent in the subsequent 12 to 24 month period. There's options to look at negotiating a percentage rental where we pay a percentage of sales as rent. The landlord and the tenant share in the downside and in the upside, and there's got to be some upside in it for the landlord. Another temporary option is to look and investigate whether you can co-let your space. The challenge is finding a comparable occupier that's complementary to what you're doing, and also getting your landlord across the line in terms of a co-location. More permanent options are looking at subletting all or part of your premises to reduce your cash flow obligations. Looking to assign part or all of your premises to reduce your cash flow options. And the key difference between a sublet and an assignment is if it's a sublet scenario, you actually retain control of the premises and that they do come back to you at the end of the sublet period. Whereas if it's an assignment, you've actually lost that right forever. There's options to look at in terms of either exit on expiry or a negotiated exit. I've done some transactions where I've had clients who've been in shopping centre leases, and for a variety of reasons we've had too much space, and the revenue that we've been generating off the premises in the shopping centre have been insufficient for the business. And we've done a negotiated assignment where we've actually split the premises in half, surrendered half back to the mall operator, and they've had another tenant come in alongside us. Or we've actually negotiated an exit out of the lease because the mall operator has had a tenant in the wings on standby. Notwithstanding that your lease says that you've still got another couple of years to run, if it's worth a conversation, and if there's a tenant sitting in the wings, most landlords will be keen to take a tenant in the hand and negotiate to bring a new tenant in that's more confident in paying rent, etc. So those options are worth exploring. Lastly, we need to consider the landlord value, and it comes back to that formula that I mentioned before. If we're looking at reducing the rental, we need to consider what can we do to improve the cap rate percentage to sustain or add value to the landlord. And the two key levers we can pull as a tenant is to increase the lease term. So there's options to look at either increasing your lease tenure or exercising a future renewal, which gives the landlord tenure certainty in that we're increasing the lease term, which adds value to the cap rate percentage. The other option to consider is we exercise a rent review that's coming up in the next 12 to 24 months. So in exchange for the landlord reducing the rent now, he knows that he or she is going to get a higher percentage in 12 or 24 months. At the end of the day, rent certainty and term certainty does have value to a landlord and does influence that cap rate. Our last step in our process is how we engage with the landlord. And I'd like to talk about mindset. I think it's very important to be kind to our landlords. They are in the same boat as us, and we simply can't transfer our cash flow problem as a tenant onto our landlord. You're not going to get a very receptive hearing. So the approach that we need to adopt, it needs to be collaborative, and we need to have a solution or an option that has some benefit in it for the landlord, as well as some benefit in it for us. And it's interesting to see that our Australian cousins across the ditch have proposed a leasing code of conduct where both landlords and tenants have a shared commitment to business continuity, both in terms of tenants' businesses as well as landlords' businesses. The next factor to consider is relationships and behaviours. A crisis brings out the best in us and also the worst in us. And I've seen some interesting behaviours over the last month, both from tenants and from landlords. I'm aware of a situation where a national tenant, as soon as it was announced that we were going into lockdown, issued a letter to all its landlords where they demanded within 48 hours a response to their request for a 3-month rent-free period. I'm also aware of a mall landlord who, when the lockdown was announced, issued an invoice for that month's rent together with a cover letter reminding the landlord of their obligations to pay the rent. And my point is that when you're communicating with your landlord, just apply the front page of the Herald test. Whatever you say, whatever you write, if you're comfortable having that republished on the front page of the Herald, it's probably good to go. If you'd be embarrassed by seeing it in the Herald, you probably want to reconsider your communication. The other point with regard to relationships is that if you set an expectation with your landlord, you need to deliver on that commitment, because the surest way to burn a relationship or to break trust is by not honouring and delivering on those commitments. And lastly, in a moment's frustration, don't burn that relationship, because the lockdown will end, the economy will recover, and you are going to have to deal with that landlord when it comes time to renew your lease for another period of time. Lastly, on process, I would encourage you to be proactive and initiate the conversation with the landlord. I'd encourage you to be open and transparent in your dealings with your landlord. You might have to share or demonstrate the impact that the lockdown and COVID-19 has had on your business. And it's about building trust in your conversation with your landlord, and a negotiation at the end of the day is between two parties, and it's very hard to argue or refuse a request that's reasonable or fair. So just before I close, I'd like to just review the 3-step process I've outlined that you can adopt in your conversations with your landlords on rebooting your lease cash flows. Review your position, develop your options, and engage with your landlord. It is a negotiation. And my closing comments are, take a second to pause and reflect. Do your homework, review your position, develop your options, engage with your landlord. And your objective is to create certainty for both you as a tenant and for your landlord in what is currently a very uncertain world. And landlords are aware, and they are probably expecting a conversation from their tenants over rental and OPEX payments. And at the end of the day, it is a symbiotic relationship. Tenants need landlords and landlords need tenants. So thank you very much, and happy to take any questions.
Thank you, Marcus. So there's a lot of detail there, and just a reminder that this is being recorded. So if you're thinking, oh, hang on, I'd like to go back and replay what Marcus just said, you do have that opportunity once we get this video processed and up onto YouTube, and you'll be emailed the link to that recording. Just a reminder that there are a number of questions that are now in the Q&A. Some of these came from the questions that you posed when registering. So we've put them up here, and Katrina has been busily answering some of those questions. If they're marked as answered, they go into the answered tab, and there's 3 questions marked that way at the moment. The remainder may be waiting for Marcus to finish his presentation, then he can get to answering those questions as well. If there's something else that you would like to ask that isn't already there, then please post that in the Q&A. And if you'd like some further clarification on something that has been answered, I believe you can do that too, and Marcus can likewise elaborate on an answer that has already been given in the answered tab. So that's your opportunity to interact with the presenters at the moment. You will have an opportunity to contact them after this presentation, and we'll let you know how to do that. So thank you, Marcus. A lot of detail there. I just have one question that seems to be coming through a lot of these questions. It's kind of a meta question, if you like, which is about leases and the ADLS's new terms that came in post the earthquake. These are terms that a lot of retailers will be dealing with as leases are renewed. Is it something that they should be proactively seeking if they are on an existing lease that doesn't already have those terms?
Generally, when you're renewing a lease, you're effectively renewing the lease on the basis that the existing terms are just rolled over into a new lease. However, hindsight is a wonderful thing, and I would possibly, when I go to renew a lease, be seeking to document the lease on the new ADLS version, or at least seek to try and incorporate the emergency access provisions into the lease renewal. So it's very easy when you're doing a renewal of lease to do a renewal and variation of lease and just import some additional terms in, and that really comes down to a matter of negotiation. From a tenant's perspective, there's a benefit of adding that term in. From a landlord's perspective, it's obviously going to cost them money, so they might be a bit more reluctant, but there's the opportunity to play the fair and reasonable card in terms of, well, the current lease document has it in. Why don't we either go to the new lease document or at least import that term in? So it's definitely worth a conversation, and I would be asking for it on my next renewal.
Fantastic. Thank you very much, Marcus. So now we'll segue to our second speaker, Katrina Hammond. So I'd like to introduce Katrina, who works for Wynne Williams as a practicing lawyer. And just a reminder that this is not, this webinar does not constitute formal legal advice. So if you are seeking an answer to a question that is particular to you and your circumstances, please do seek that formal legal advice. Although you can approach both our speakers today as a way of opening that conversation. So, Katrina.
Thank you. Thanks for the disclaimer as well. That's very helpful. Usually it's the lawyers throwing the disclaimers around, so thanks for doing the bad cop chore there for me. So my topics today are quite vast, so I've got quite a bit to cover in this session. I guess the theme of my presentation is just putting a legal lens over what is the new retail environment, which has already changed quite rapidly with the rise of some retailers being able to start trading, although with more focus on e-commerce and respecting social distancing, of course. So the topics which I'm going to cover, I'll give a couple of comments on retail leasing. I'll talk a little bit about what the government's indicated they're going to do in some sort of trans-Tasman perspectives, and we'll look at e-commerce, contactless retail, and I'll try and provide some tips there. We'll quickly look at the existing consumer obligations and then some other privacy law compliance aspects which apply with this change to the retail environment, and then we'll look at advertising and marketing, and that's really just some common traps. So I don't want to sort of rehash things that most of you are already aware of, but I think there's some timely reminders in there. So in terms of retail leasing, you know, like Marcus, I've been busy over the last couple of weeks helping particularly tenants negotiate rental abatements and other forms of relief under their leases. I think it's been unfortunate that we haven't had a faster response from government in terms of helping with rental relief. And as Marcus mentioned, you know, after the labour costs in your business, the occupancy cost is normally the next largest cost for you. So at the moment, the wage subsidy was able to be quickly launched. It didn't require legislation to be amended or bills to be passed, whereas with commercial leasing, it requires amendment to the Property Law Act. So we've heard from Marcus about the ability to issue the Property Law Act notice, which enables a landlord to terminate a lease. Instead of on 10 working days, it would be on 30. So that's non-payment of rent. The other thing that we've seen is the government respond to some, I guess, lobbying and concerns expressed by 8 different business and industry groups, which basically included Retail New Zealand, the Franchise Association, Hospitality New Zealand, and that did generate some sort of response from government, and we've heard that they're going to start looking at some options to better support tenants and to support landlords as well, with ideally just, you know, bringing the parties to the table to negotiate. So at the moment, there's been mentioned that the government would look to the Australian Leasing Code. That would be helpful. It may not be the solution that's right for everybody's business, but it is at least a framework that has been helpful in Australia. So in terms of what we're doing, it's quite similar in terms of but just approaching landlords with a really transparent and fulsome response in terms of setting out exactly the position that a tenant's business is in, and then putting forward some suggestions for what a fair proportion of rent and outgoings might look like. And to be honest, the ADLS lease, although it's got that clause, it still requires negotiation. It doesn't set out a method for calculating what is a fair proportion. So in some respects, you're sort of saying, well, even if your lease has got it, this is best practice and we should be talking about this, and just putting out all the options and being prepared to provide a lot of financial information about your business and how it's been impacted. So that's the way that we're sort of handling those discussions with landlords. It's easier for us if we get involved at the outset. If you haven't opened those conversations, it's important that you do. Don't wait for government announcements or codes and things like that. If you have had conversations and they're not going well, or you don't think that the response from your landlord is fair, then I think it is helpful to get an independent person involved to just cut through what are quite emotional issues, particularly for smaller businesses. So there's quite a few questions coming through on the Q&A, so hopefully we can cover those at the end. But just one point to note, most insurance policies will not apply, and that's in terms of business interruption insurance as well. And you know, my understanding from our insurance team is that was off the back of the earlier SARS outbreak. A lot of insurance policies specifically exclude pandemics now. So it was thought initially that there might be some pots of gold there, like we saw after the Canterbury earthquakes, but that's not the case. So we'll move on quickly to e-commerce and contactless retail. So most of you, if you weren't operating online, you probably are now, or have upped your e-commerce game. So we've seen an increase in supply, an increase in demand, and then the issues that have flowed through with that. So delays in receiving product, and then delays in delivering products to consumer. So it's really important, I guess, that if you have made price promises or delivery promises or guarantees, or you've got terms and conditions on your websites, that you reflect on whether those are accurate at the moment. So I'm hoping that most of you have sort of got through the worst of those delays and interruptions to your business. But if you're still experiencing those sorts of delays, or you know, you're not able to deliver the service which you otherwise normally would, then make sure you're really clear and upfront about that on your website. Also just thinking from the consumer's perspective about return of products. So if you've got a return window of say 14 days or whatever, it's the time right now where you're going to have to start relaxing those sorts of requirements. So just have a think about both products sold online and in store, whether the challenges now for consumers excuse me, mean that they need to push out those window returns. So 41% of your shoppers in an online environment would generally purchase things with the intention of returning some of those items. So that's a stat from Shopify. But the same applies for your bricks and mortar stores. You know, there's going to be some delays in terms of people being able to return products. So just reflect on those policies and have an understanding approach to what your return windows look like. The issue there, though, of course, is the financial impact on your business, particularly if you've got seasonality of products. So fashion retail is a very good example. You know, you're going to be taking returns potentially of products which are suited for, you know, the end of summer or autumn. So that's going to create a further financial strain on your business. But, you know, ideally you're just probably going to have to suck it up and take the hit there, but focus on building customer loyalty and doing the right thing by your customers. The next thing I think which is important to just quickly cover off on, like nothing's changed in terms of intellectual property law, but I think it's really important just to consider the amount of content that you're pushing out on social media channels and on your websites. Just remember to turn your mind to intellectual property. Make sure you're using your trademarks correctly. Make sure you're not infringing on other parties' trademarks. And if you've started to use video content, just make sure that you have the appropriate consents. Make sure you've got releases from people that appear in those videos if you're going to start pushing out that sort of video content through your online channels. The other thing to consider, which is something we're seeing a lot in retail, is, you know, there's a lot of retailers who are pivoting and introducing new ranges of products or dabbling in different areas that they wouldn't normally dabble in. Also launching new brands. So just take stock, have a little think about whether those are maybe medium to longer term objectives for your business. If they are, then it might warrant you protecting those new brands or expanding your existing trademark protections to capture new product lines or new services that you might be offering. The next thing, which obviously everyone's been pushing a bit harder on, is the social media platforms, but use of user-generated content and influencers for endorsements and things. So there's been quite a bit of publicity around the use of influencers and people endorsing products and services over the last couple of years. But just a quick reminder, make sure you've got the appropriate policies in terms of being able to take down and remove content which is posted to your social media platforms by your users. And if you are looking at using influencers, or you're just recently starting to do that, just make sure that you're making the appropriate disclosures so you don't offend your customers by not being, you know, upfront and transparent about paid endorsements. The other thing just to remember is that if you have got endorsements or reviews on your website which are provided by customers or those paid providers, just make sure that those are expressed correctly if you're going to sort of reshare them as part of your own marketing material. So if you use those sorts of comments as your own marketing and in your own advertising, you'll be responsible for those at law as if they're, you know, your comments. So just make sure that those comments that you reshare and incorporate in your marketing don't create a misleading or false impression in a consumer's mind. The next thing, which is linked to the sort of increase in influencers as well as user-generated content, is the reviews and testimonials. So we've seen the Commerce Commission pay quite a significant amount of attention to this and also respond to consumer and competitor complaints. So last year, Batch Care was fined $117,000 for misleading consumers. And I appreciate that's not retail, but what it does show is that if you alter or withhold online reviews to the favour of your brand, then this will ultimately attract the attention of the likes of the Commerce Commission. And as with many other complaints at consumer law, it is likely your competitors that tip off those sorts of complaints. So just be mindful of that. Refer a friend campaigns. There's been quite a big rise in those, and just in terms of my experience and sort of keeping an eye on what some of the delivery providers are doing online in terms of food boxes and the like. Just make sure that when you're doing those refer a friend campaigns that you're complying with the Unsolicited Messages Act or spam requirements. It's pretty easy to get that wrong and quickly offend potential new customers and attract adverse brand and reputation attention in the media. Right, the next topic, contactless retail, which there's not new laws that apply to this. It's actually a bit challenging to talk about this topic. I think we need to sort of reflect on health and safety and how that relates to contactless retail. So, just being aware of what you can and can't do in your premises when you start allowing, for example, the one in, one out policy in some of the retail outlets. So make sure that you've got the appropriate health and safety plan in place, but then also think about fire safety, respecting the exit access ways, and making sure that you're not blocking or impairing visibility of those sorts of signs and things for emergency exits. One thing that I've noticed as well is the use of tables and things at the front of a strip retail outlet. So you've got your cafes and things. A huge table across the doorway might look good to facilitate payment and pick up of product, but again, that's probably creating quite a significant risk in terms of access in and out of the premises for your employees. So when you're setting up these new ways of engaging with your consumers, just remember to reflect on how that also impacts the safety of your employees. The next thing is the guest registers. So this is a requirement, obviously, from the Ministry of Health to make sure that we can meet all the contact tracing requirements. Just make sure that you're respectful of who can see that register and that your employees understand the importance of maintaining that register. And I'll touch a little bit further on in terms of privacy law considerations there. And then crowd control, that's one we've seen in the media recently. Poor old Burger Fuel has attracted a lot of attention there. Maybe it's still good publicity in some regards, but it's unusual. We're not normally responsible for the footpath or the part of the sort of exterior part of premises which we don't lease, and that's within shopping centres as well. But hopefully shopping centres and shopping malls will provide some support to retailers as to, cordoning off areas for people to queue safely with the social distancing requirements. But normally you wouldn't be responsible for that sort of crowd control, and unfortunately this is going to cut into the margin further for retailers, because the likes of Burger Fuel are now hiring security guards to try and control crowds. So I'm not sure that there's much from a legal perspective that I can point to as to what would allow a business to be, for example, closed down for not respecting the social distancing requirements. But it's very clear from the government that if you cannot operate and respect those social distancing requirements, then you shouldn't open your business. So look at your processes and procedures, make sure that you're doing everything you can, and also document those. So if you do run into issues, you can at least substantiate that you did try and put in place practices and mitigate the risk of that becoming an issue. So the next consumer and privacy law considerations, which I thought would be important just to touch on. Same thing again, nothing's changed with consumer law. There's no changes to consumer law. It's just more of a kind of reminder to just remember, and amongst this increase in competition and slight desperation for consumer and market share, just don't forget your responsibilities in terms of consumer refunds. Usual guarantees apply. If you've got return windows, which we've talked about, or warranties that you're offering, you'll need to relax the timeframes around those to make sure that they're fair. With your product claims, the other thing to just consider is damage while in transit. So if you've got products being delivered by couriers and things and there's complaints coming through, just have a strategy in place to deal with return of products that are damaged, and make sure you're clear with your delivery provider as to who's liable for that. With your product claims, just be very careful in your advertising in-store, online and in print media. Just making claims, make sure they're accurate, make sure you can substantiate them. The Commerce Commission and other global regulators like the ACCC in Australia will bring action in terms of investigations if you're making claims that you can't substantiate. So the focus at the moment will be on health claims, potentially environmental claims as well. So if you're making claims like eradicates all germs or guaranteed to decontaminate, things like that, just be very careful of that. But then just your usual claims, if you're saying it's cheaper or superior or better value than a competitor's products, make sure that you have evidence of that. So basically make sure everything's accurate and you've got records in case you are subject to an investigation. The next thing is stock levels and delays, and this has been a challenge for most retailers, firstly to meet demand, but then to also restock your products. So try and stay close to your suppliers, make sure you understand their ability to meet your demands, and try and get some forecasting as to what delays that they're going to experience. If you don't have products in stock, or if you're not able to meet demand, clearly just set that out on your website or make sure it's clear in store. There's nothing worse than consumers investing significant time sort of shopping online or investigating products to only find that you won't be able to supply those for weeks or months. So just think about the potential for brand and reputation damage again if you're not clear and upfront with your communication. So the next point I wanted to quickly look at was privacy law considerations. So I guess we've seen Countdown in the media. They've had a priority service, so that was for elderly or immunocompromised customers. They've been collecting quite detailed health information. Some consumers have felt uncomfortable with providing things like a letter from their doctor. So if you are collecting that sort of information, just make sure that you're clear about the reasons why, how it will be stored, and what you're going to use it for. There are also additional obligations in connection with storage of that sort of sensitive information. So if you're new to collecting that sort of data about people's health, then just check in with your legal advisor and make sure that you're compliant with the privacy principles there. And then the guest register I touched on briefly. It's not a new marketing database. It should be purely for the purposes of contract tracing. It should only be kept for 4 weeks. And again, that's got sensitive information. Your employees need to understand what it can and can't be used for. They also need to respect the fact that if someone does test positive for COVID-19, then that's sensitive information as well. So you're just going to have procedures in place and make sure your employees are well aware of the purpose of that register. If you do want to use that information, you can. You just need the proper steps in place as you normally would with collecting that sort of information. Have an affirmative opt-in from consumers to make sure that they've given the appropriate consents to you using that information for another purpose. Some of the food service providers are using delivery apps, third-party provider apps, and make sure that you understand what information that's collected by those third-party providers is actually something you can have access to, and always double check that the appropriate process has been followed for gaining consent from a consumer. The next item I just want to quickly cover is the advertising and marketing common traps. Again, there's no changes to law here. The Commerce Commission and the Advertising Standards Authority will continue to regulate this area, they'll investigate and respond to complaints. It's really important that if you receive correspondence from the Commerce Commission or the Advertising Standards Authority, that you treat those seriously. Seek advice. It can blow out quite quickly, and the timeframes for responding to those sorts of complaints can be quite tight. So just remember also, it's often a competitor who does tip off the Commerce Commission or the Advertising Standards Authority. So, you know, don't think it's just a one-off disgruntled consumer complaint. Often there's been a bit of a watch on your behaviour for a period of time. So those sorts of investigations can take a huge amount of time, and depending on the size of your business, a smaller business, it's a complete distraction. Larger companies, it's just to be honest, a bit of a waste of management time and attention, the level of attention that you need to give those sort of complaints. So it's best obviously to try and work within the playing field and stick to promotions that don't make misleading claims, that don't create a false representation in the consumer's mind. Make sure you're clear and accurate in all of your advertising. The common sort of risk areas are the ones that I've listed on that slide. Sale periods is a big issue. If you're on sale, you need to be really truly on sale, and we all know the retailers that seem to be constantly on sale, but no matter what the size of your business, you should still be very mindful of sales should be short, and they should really truly reflect for example, was now price based on the actual price sold for last, not a recommended retail or a ticket price that you've never used. Try not to use fine print, particularly if it's to clarify an otherwise misleading impression in your advertising. If you're discounting, make sure it's very clear. Try not to use bait advertising to lure consumers into your retail outlet, online or bricks and mortar. Be very, very careful if you're starting to do clearance sales, particularly around closing down or end of lease sales, which unfortunately we will be seeing some of those. So we've advised clients in the past to just be very careful about the sort of broad claims like everything must go, everything's discounted, or sale must end when lease ends, because in reality often those dates slide. So if you need any more of a deterrent, you can look at some of the recent fines. Bunnings was fined $600,000, Bike Barn $800,000, Michael Hill $16,000 for misleading promotional pricing. So just take care, and the same rules still apply, but I think the closing down or the clearance sale one is where you're going to probably attract the most attention. So that's sort of my quick run through and some tips and common traps in terms of those areas around, e-commerce and marketing and advertising. There's some important privacy considerations there, which I think are really important to just make sure your teams are aware of. And I'll try and run through these questions now and hand back to Andrew. But if you want to jump on LinkedIn, I've got a bit of video content there around the leasing issues, and happy to facilitate questions and answers via LinkedIn or via email in the coming days. So happy to help if you've got any issues.
Fantastic. Thank you, Katrina. I'll give you a minute or so to collect your breath and take a sip of water and take a look at those questions as well. Although I will pose you a question, which hopefully won't challenge you too much, and that is picking up on the question about returns. I have seen this posed in the media, although not on the questions today. Products that come back, do they need to be disinfected? So contactless is easy going out of the store, but how does it work coming back in, particularly for things like clothing?
Yeah, so it's a good question. I haven't really thought of that, but I think I have an answer to that. I would be looking at the guidelines in terms of what we've seen from the World Health Organization as to how long traces of the virus can sort of last on various types of surfaces. So I can't recall what it was on fabric. I think it was something like 5 days. So check that. So if you've got, say, a fashion item, I think that you'd be wanting to sort of put that to the side and not have your employees touch that unless they've got gloves and disinfectant and hand sanitizer, and try and just prioritize how you, I guess, engage with and touch the products that are being returned based on those World Health Organization guidelines. I don't think it's viable to rely on a consumer to do that. A consumer will chuck it in a bag and return it. It's more your obligations as an employer and keeping your employees safe that I'd be concerned about.
And a related issue was my experience yesterday, just to give a personal anecdote. I went and purchased something from Kmart and had to go and drive into the car park, and they had tables all set up. It was all very organized, all numbered, and a phone number to call for them to come and deliver things. But then the staff in that store were having to stand outside in the pouring rain to actually give the products to the customers who are happily waiting in their nicely warm and dry cars. So there are many health and safety considerations to think about, including that your store may now be operating in a car park as well as in the store itself, and what that might mean for staff. So more of a comment.
Yeah, absolutely. Yeah.
Just picking up on something that you said there, and I will just change my background to update to next week's webinar, which is on customer engagement and digital marketing, which reflects some of the comments that Katrina has just made. We will have a future webinar, not number 4, I think it might be number 5, that's also going to consider contact tracing apps and other ways that you can manage that process more efficiently than perhaps just having a sheet of paper at the door with a common pen that everyone is touching to register their details. So there's a lot going on in that space. It's a rapidly evolving space, but hopefully we'll have some ideas for you to think about. So this is just a promo for next week. We have 2 excellent speakers coming to talk. Dave Hughes from Evolve Business Insights and Wendy Thompson from Socialites NZ. They're both experts in digital marketing and have some great perspectives to share. So the questions from today, there's a number there waiting to be answered. We are going to share both the questions and answers in a written document alongside the video once it's processed. The written questions we can't include in the recording. All you see is what the speakers have focused upon. And so they don't appear in the YouTube recording either. So we're putting our heads around how to get those written questions and answers out to you. Obviously, if it's a specific question and you've addressed it to the panelist, then to the speaker, then you'll have got hopefully a direct answer back. But for questions that you've seen that you would like to see what the answer is, with a bit of luck, we will have the ability to put up that Q&A alongside the video on the Massey Business School page, and we will alert you to that location when it is ready, which hopefully will be tomorrow or on Friday. Any final comments from either presenter? Putting you on the spot there, of course.
Can you hear me?
Yes, we can.
Right, sorry, I'm showing as muted, but I think it's important just to, there's so many questions here about trying to get landlords to engage and if they're not replying and what to do next. I think it's really important to just take the time to take some advice, and it doesn't have to be a huge amount of sort of legal cost or spend with someone like Marcus or I. It's just trying to, I guess, take the emotions out, cut through to the facts, and really generate a reply to your landlord that actually forces them to stop and pay attention. Some of the emails and things that I've seen with tenants who are rightly, pretty stressed about the situation they're in, aren't really cutting to the detail that matter to the landlord. And it doesn't mean that we're saying to you that you've got to sort of pander to the landlord's requirements. It's just actually making sure that you're giving them absolutely everything they need so they have no excuse to keep dragging out the discussions with you, and then they've got a response. If that doesn't generate the response that you want, it's still good work done, because if you end up in an arbitration setting or a dispute with your landlord, all of that will be great evidence to prove that you've, you know, been reasonable, you've taken all the steps you can, and your landlord's actually acting very unreasonably. So don't see it as time or money wasted. Look at it as, I guess, an opportunity for you to set the stage for what could be a dispute going forward, unfortunately.
Thank you, Katrina. And Marcus, any final comments?
I'd support Katrina's comments. I think when it comes to engaging with a landlord, I really come back to that pause and actually think about how you're engaging, because there's two parts to the conversation. There's the content part and there's the process part. And put yourself in the shoes of the landlord. If people are ringing up saying, "Hey, I need a rent rebate, you know, I can't afford to pay the rent," those are the sort of conversations that landlords are not going to enjoy, because they're difficult conversations and they're not exactly going to be picking up the phone to return your calls. So you really need to think about what is it I can offer the landlord? How am I going to engage with the landlord so that I actually get the landlord's attention? And how do I get the landlord to the table? There's got to be something in it for the landlord to get them to engage, because otherwise you're basically trying to transfer your cash flow problem onto them. So that would be my main sort of advice. And a lot of the questions that have come through, while we can provide general advice, it's really quite fact specific, and need to understand, first of all, what the lease scenario is, need to understand what the fact scenario is around, you know, what's the type of property, where it's located. Because at the end of the day, I keep coming back to the symbiotic relationship. The landlord's got a vested interest in making sure that the tenant's business survives. Otherwise, they've got a vacant building and the value of their building plunges by 25% to be a minimum. So there is definitely an incentive for a landlord to have a conversation with regard to what can I do to keep my tenant engaged, because if my tenant doesn't survive, it's going to be quite challenging in the current market to find a replacement tenant.
Yes, fantastic. Thank you very much, Marcus. And thank you both presenters, Marcus and Katrina. Some excellent presentations there, lots of food for thought. And just a reminder, you'll be able to see this recording again. So if your head's spinning a little bit from all that detail, and there was plenty of it, then you can go back and watch it once we've processed the video and made it available. So thank you everyone for your attendance today. It's a great attendance, a lot of people watching in, and I'm sure this recording will have a life beyond today as it gets promulgated through the networks, including in Stuff, their Prosper page for SMEs are now publicising these webinars starting today and going forward. So thank you to everyone for your participation, and to our supporters at Retail X who make these fantastic banners and click art, and to Retail New Zealand who promote this to their network, ATEED, and many other business organisations who are trying to get the message out to small businesses everywhere, how they can survive and prosper. Thank you very much for your time. See you again.
Thank you.
Thank you.